I am coming with one more part of the Union Executive in the series of our Constitution. The Council of Ministers, the framers of our Constitution, intended that though formally all executive powers were vested in the President, he should act as the constitutional head of the executive like the English Crown, acting on the advice of ministers responsible to the popular house of the legislature. But while the English Constitution leaves the entire system of cabinet government to convention, the Crown being legally vested with absolute powers and the ministers being in theory nothing more than the servant of the Crown. The framers of our Constitution enshrined the foundation of the cabinet system in the body of the written Constitution itself, though of course the details of its working had necessarily to be left to be filled up by the convention and usage. While the Prime Minister is selected by the President, the other ministers are appointed by the President on the advice of the Prime Minister. Article 75(1), and the allocation of portfolios amongst them is also made by him. Further, the President's power of dismissing an individual minister is virtually a power in the hands of the Prime Minister. In selecting the Prime Minister, the President must obviously be restricted to the leader of the party in a majority in the House of the People, or a person who is in the position to win the confidence of the majority of that House. The number of members of the Council of Ministers is not specified in the Constitution. It is determined according to the exigencies of the time. At the end of 1961, the strength of the Council of Ministers of the Union was 47. At the end of 1975, it was raised to 60, and in 1977, it was reduced to 24, while in July 1989, it was again raised to 58. The National Front government, headed by Sri V.P. Singh, started with only 22 ministers. All the ministers, however, do not belong to the same rank. The National Democratic Alliance government, headed by Mr. A.B. Vajpayee, has 29 cabinet ministers and 44 state ministers, no deputy ministers. The Constitution does not classify the members of the Council of Ministers into different ranks. All this has been done informally following the English practice. It has now got legislative sanction so far as the Union is concerned in Section 2 of the Salaries and Allowances of the Ministers Act 1952, which defines minister as a member of the Council of Ministers by whatever name called and includes a deputy minister. The Council of Ministers is thus a composite body consisting of different categories at the center. These categories are there as stated above. The salaries and allowances of ministers shall be such a parliament may from time to time by law determine. Each minister gets a sumptuary allowance at a varying scale according to his rank and a residence free of rent. The rank of the different ministers is determined by the Prime Minister, according to whose advice the President appoints the minister. Article 75(1), and also allocates business amongst them. Article 77, while the Council of Ministers is collectively responsible to the House of the People. Article 75(3). Article 75(c) enjoins the Prime Minister, when required by the President, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by the Minister but which has not been considered by the Council. In practice, the Council of Ministers seldom meets as a body. It is the Cabinet, an inner body within the Council, which shapes the policy of the government. While cabinet ministers attend meetings of the cabinet of their own right, ministers of state are not members of the cabinet, and they can attend only if invited to attend any particular meeting. A deputy minister assists the minister in charge of the department of ministry and takes no part in cabinet deliberations. Ministers may be chosen from members members of the House, and a minister who is a member of one House has a right to speak in and to take part in the proceeding of the other House, though he has no right to vote in the House of which he is not a member. Article 88. Under our Constitution, there is no bar to the appointment of a person from outside the legislature as minister, but he cannot continue as minister for more than 6 months unless he secures a seat in either House of Parliament by election or nomination, as the case may be. In the meantime, Article 75(5) says, a minister who has any period of 6 consecutive months is not a member of either House of Parliament shall be at the expiration of that period cease to be a minister. As to ministerial responsibility, it may be stated that the Constitution follows in the main the English principle, except as to legal responsibility of individual ministers for acts done by or on behalf of the President. The principle of collective responsibility is confided in Article 75(3) of the Constitution. The Council of Ministers shall be collectively responsible to the House of the people. So, the ministry as a body shall be under the constitutional obligation to resign as soon as it loses the confidence of the popular House of the legislature. The collective responsibility is to the House of the people, even though some of the ministers may be members of the councils of states. The collective responsibility has two meanings. The first, that all the members of the government are unanimous in support of its policies and exhibit that unanimity on public occasions, although while formulating the policies they might have differed in the cabinet meetings. The second, that the ministers who had an opportunity to speak for or against the policies in the cabinet are thereby personally and morally responsible for their success and failure. Of course, instead of resigning, the ministry shall be competent to advise the President or the Governor to exercise its power of dissolving the legislature on the ground that the House does not represent the views of the electorate faithfully. The principle of individual responsibility to head the state of the state is embodied in Article 75(2). The ministers shall hold office during the pleasure of the President. The result in that, though the ministers are collectively responsible to the legislature, they shall be individually responsible to the executive head and shall be liable to dismissal even when they may have the confidence of the legislature. But since the Prime Minister's advice will be available in the matter of dismissing other ministers individually, it may be expected that this power of the President will virtually be, as the England, a power of the Prime Minister against his colleagues to get rid of an undesirable colleagues, even where the minister may still possess the confidence of the confidence of the majority in the House of the people. Usually the Prime Minister exercises this power by asking an undesirable colleague to resign, which the latter readily complies with in order to avoid the odium of the dismissal. But as stated earlier, the English principle of legal responsibility has not been adopted in our Constitution. In England, the Crown cannot do any public act without the counter signature of a minister, who is liable in the court of law if the act done violates the law of the land and gives rise to the cause of action in favor of the individual. But our Constitution does not expressly say that President can act only through ministers and leave it to the President to make rules as to how his orders, etc., are to be authenticated, and on the other hand provides that the courts will not be entitled to inquire what advice was tendered by the ministers to the executive head. Hence, if an act of the President is according to the rules made by him, authenticated by the Secretary to the Government of India, there is no scope for minister being legally responsible for the act, even though it may have been done on the advice of the minister. As in England, the Prime Minister is the keystone of the cabinet. Article 74(1) of our Constitution expressly states that Prime Minister shall be at the head of the Council of Ministers. Hence, the other ministers cannot function when the Prime Minister dies or resigns. In England, the position of the Prime Minister has been described by Lord Morley as primus inter pares, first among equals. In theory, all ministers or members of the cabinet have an equal position, all being advisors of the crown and all being responsible to parliament in the same manner. Nevertheless, the prime minister has a preeminence by convention and usage. Thus, the prime minister is the leader of the party in majority in popular house of the legislature. He has the power of selecting the other ministers and also advising the crown to dismiss any of them individually or require any of them to resign virtually. Thus, the other ministers hold office at the pleasure of the prime minister. The allocation of business among the ministers is a function of the prime minister. He can also transfer the minister from one department to another. He is the chairman of the cabinet, summons its meeting and presides over them. While the resignation of other ministers merely creates a vacancy, the resignation or death of the prime minister dissolves the cabinet. The prime minister stands between the crown and the cabinet. Though individual ministers have the right of access to the crown on matters concerning their own departments, any important communication, particularly relating to policy, can be made only through the prime minister. He is in charge of coordinating the policy of the government and has accordingly a right of supervision over all the departments. In India, all these special powers will belong to the prime minister inasmuch as the convention relating to the cabinet government are in general applicable, but some of these have been codified in the constitution itself. The power of advising the president as regards the appointment of other ministers is thus embodied in Article 75(1) as to the function of acting as the channel of communication between the president and the council of ministers. Article 78 provides it shall be the duty of the prime minister to communicate to the president all decisions of the council of ministers relating to the administration of affairs of the union and the proposals for legislation, to furnish such information relating to the administration of the affairs of the union and proposals for legislation as the president may call for, and if the president so requires, to submit for the consideration of the council of ministers any matter on which a decision has been taken by the minister but which has not been considered by the council. Thus, even though any particular minister has tendered any advice to the president without placing it before the council of ministers, the president has, through the prime minister, the power to refer the matter to be considered by the council of ministers. The unity of the cabinet system will thus be enforced in India through the provisions of the written constitution. The president in relation to his council of ministers. It is no wonder that position of the president under our constitution has evoked much interest among political scientists in view of the plenitude of powers vested in an elected president holding for a fixed term, saddled with limitations of cabinet responsibility. In the parliamentary form of government, the tenure of office of the virtual executive is dependent on the will of the legislature. In presidential government, the tenure of office of the executive is independent of the will of the legislature. Leacock. Thus, in the presidential form of which the model of the United States, the president is the real head of the executive who is elected by the people for a fixed term. He is independent of the legislature as regards his tenure and is not responsible to the legislature for his acts. He may, of course, act with the advice of ministers, but they are appointed by him as his councillors and are responsible to him and not to the legislature. Under the parliamentary system represented by England, on the other hand, the head of the executive, the crown, is a mere titular head, and the virtual executive power is wielded by the cabinet, a body formed of the ministers of legislature and responsible to the popular house of the legislature for their office and actions, being A republic, India could not have the hereditary monarch, so an elected president is at the head of the executive power in India. The tenure of his office is for a fixed term of years, as of the American president. He also assembles the American president inasmuch as he is removable by the legislature under the special quasi-judicial procedure of impeachment. But on the other hand, he is more akin to the English king than the American president insofar as he has no function to discharge on his own authority. All the powers and functions, Article 74(1), that are vested by the Constitution in the President are to be exercised on the advice of the ministers responsible to the legislature, as in England. While the so-called Cabinet of the America, President is responsible to himself and not to Congress. The Council of Ministers of our President shall be responsible to Parliament. The reason why the framers of our Constitution discarded the American model after providing for the election of the President of the Republic by an electoral college formed of members of the legislature, not only of the Union but also of the states, has thus been explained. In combining stability with responsibility, they gave more importance to the latter and preferred the system of daily assessment of responsibility to the theory of periodic assessment upon which the American system is founded. Under the American system, conflicts are bound to occur between the executive, legislature and judiciary, and on the other hand, according to many modern American writers, the absence of coordination between the legislature and executive is a source of weakness of the American political system. What is wanted in India on her attaining freedom from one and a half century of bondage is a smooth form of government which would be conducive to the manifold development of the country without the least friction. And to this end, the cabinet or parliamentary system of government, of which India has already had some experience, is better suited than the presidential. A more debatable question that has been raised is whether the Constitution obliges the President to act only on the advice of the Council of Ministers on the every matter. The controversy on this question was highlighted by a speech delivered by the President Dr. Rajendra Prasad at a ceremony of the India Law Institute November 8, 1960, where he urged for the study of relationship between the President and the Council of Ministers, observing that there is no provision in the Constitution which in so many words lays down that the President shall be bound to act in accordance with the advice of his Council of Ministers. The above observation came in contrast with the word of Dr. Rajendra Prasad himself, with which he, as the President of the Constituent Assembly, summed up the relevant provisions of the draft Constitution. Although there is no specific provision in the Constitution itself making it binding on the President to accept the advice of his ministers, it is hoped that the convention under which in England the king always acted on the advice of his ministers would be established in this country also, and the President would become a constitutional president in all matters. Politicians and scholars naturally took side on this issue, advancing different provisions of the Constitution to demonstrate that the President under our Constitution is not a figurehead munshi, or that he was a mere constitutional head similar to the English crown. When the question went up to the Supreme Court, the court took the latter view, relying on the interpretation of the words "aid and advise" in the Dominion Constitution Acts. In these words, in Rajway's case, under Article 53(1) of our Constitution, the executive power of the Union is vested in the President, but under Article 74, there is to be Council of Ministers with the Prime Minister at the head to aid and advise President to the exercise of his functions. The President has thus been made a formal or constitutional head of the executive, and the real executive power are vested in the Minister or the Cabinet. cabinet. The same provision obtained in regard to the government of states. The governor occupies the position of the head of the executive in the state, but it is virtually the council of ministers in each state that carries on the executive government in the Indian constitution. Therefore, we have the same system of parliamentary executive as in England, and the council of ministers consisting as it does of the members of the legislature is like the British cabinet, a hyphen which joins a buckle which fastens the legislative part of the state to the executive part. The foregoing interpretation was reiterated by the Supreme Court in several later decisions, so that in so far as judicial interpretation was concerned, it was settled that the Indian president is a constitutional head of the executive like the British crown. In Rao versus Indira, a unanimous court observed the Constituent Assembly does not choose the president's system of government. The Indira government sought to put the question beyond political controversy by amending the constitution itself. Article 74(1) was thus substituted by the Constitution 42nd Amendment Act 1976. There shall be a council of ministers with the Prime Minister as the head of the head and advise the President, who shall in the exercise of his functions act in accordance with such advice. Though the Janata government sought to wipe off the radical changes infused into the constitution by Indira Gandhi government, it has not disturbed the foregoing amendment. The foregoing amendment made in Article 74(1), the only change made by the 44th Amendment over the 1976 provision is to add a proviso which gives the President one chance to refer the advice given to the Council of Ministers back for the reconsideration. But if the Council of Ministers reaffirm their previous advice, the President shall be bound to act according to that advice. Article 74(1) as it stands after the 44th Amendment 1978 stands thus: there shall be a council of ministers with Prime Minister at the head to aid and advise the President, who shall in the exercise of his function act in accordance with such advice, provided that the President may require the council of ministers to reconsider such advice either generally or otherwise, and the President shall act in accordance with the advice tendered after such reconsideration. The position today, therefore, is that the debate whether the President of India has any power to act contrary to the advice given by the Council of Ministers has become meaningless. By amending the Constitution in 1976 and 1978, a seal has been put to the controversy which has been mooted by President Rajendra Prasad at the Indian Law Institute, that there was no provision in the Indian Constitution to make it obligatory upon the President to act only in accordance with the advice tendered by the Council of Ministers on each occasion and under all circumstances. But at the same time, the amendment so made has erred on the other side by making it an absolute proposition without keeping any reserve for situation when the advice of the Prime Minister is not available, as for example in the case of death, or the advice tendered by the Prime Minister is improper according to British conventions, as for example when Prime Minister defeated in Parliament successively asked for its dissolution. So far as the contingency arising from the death of the Prime Minister is concerned, it instantly operates to dissolve the existing Council of Ministers. Hence it would appear that notwithstanding the 1976-78 amendment of Article 74(1), the President shall have the power of acting without prime ministerial advice during the time taken in the matter of choosing a new Prime Minister, who of course must command majority in the House of the people. In this contingency, no Council of Ministers exists on the death of the while Prime Minister. But as regards to the contingency arising out of the demand for dissolution by the Prime Minister who is defeated in the House of the People, it cannot be said that no Council of Ministers is in existence. On the amended Article 74(1), the President of India must act upon the request of the defeated Council of Ministers, even if such request is improper, as for example on a second occasion of defeat. If so, the position in India would differ from the principles of cabinet government as they prevail in the UK. The Attorney General for India, the office of the Attorney General is one of the offices placed on a special footing by Constitution. He is the first law officer of the Government of India, and as such his duty shall be to give advice on such legal matters and to perform such other duties of legal character as may from time to time be referred or assigned to him by the President, and to discharge the function conferred upon him by Constitution or any other law for the time being in force. Though the Attorney General of India is not, as in England, a member of the cabinet, he shall also have the right to speak in the Houses of Parliament or in any committee thereof, but shall have no right to vote. Article 88. By virtue of his office, he is entitled to the privilege of a member of the Parliament. Article 105(4). In performance of his official duties, the Attorney General shall have a right of audience in all courts in the territory of India. The Attorney General of India shall be appointed by the President and shall hold office during the pleasure of the President. He must have the same qualification as are required to be a judge to the Supreme Court. He shall receive such remuneration as the President may determine, and the President has determined that the Attorney General shall be paid a monthly retainer of rupees 5,000, but he is not a whole-time counsel for the government nor a government servant. The Comptroller and Auditor General of India. Another pivotal office in the Government of India is that of Comptroller and Auditor General, who controls the entire financial system of the country. Article 148 at the union as well as state levels. As observed by Ambedkar, the Comptroller and Auditor General of India shall be the most important officer under the Constitution of India, for he is to be guardian of the public purse, and it is his duty to see that not a farthing is spent out of the consolidated fund of India or of the state without the authority of the appropriate legislature. In short, he shall be the impartial head of the audit and account system of India. In order to discharge his duty properly, it is highly essential that this office should be independent of any control of the executive. The foundation of parliamentary system of government, as has been already seen, is the responsibility of the executive of the legislature, and the essence of such control lies in the system of financial control by the legislature. In order to enable the legislature to discharge this function properly, it is essential that this legislature should be aided by an agency fully independent of the executive, who would scrutinize the financial transactions of the government and bring the results of such scrutiny before the legislature. There was an Auditor General of India even under the Government of India Act 1935, and that act secured the independence of the Auditor General by making him irremovable except in like manner and or the like grounds as a judge of the federal court. The office of the Comptroller and Auditor General in the Constitution is substantially modeled upon that of Auditor General under the Government of India Act 1935. The independence of Comptroller and Auditor General has been has been sought to be secured by following provisions of the Constitution. Though appointed by the President, the Comptroller and Auditor General may be removed only on the address from both houses of Parliament on the ground proved misbehavior incapacity. He is thus excepted from the general rule that all civil servants of the Union hold their office at the pleasure of the President. Article 310(1). His salary and conditions of service shall be statutory, that is, as laid down by the Parliament, by law, and shall not be liable to variation of his disadvantages during his term of office. Under this power, Parliament has enacted the Comptroller and Auditor General's Conditions of Service Act 1971, which, as amended, provides as follows: the term of office of Comptroller and Auditor General shall be 6 years from the date on which he assumes office, but he shall vacate office on attaining the age of 65 years if earlier than the expiry of the 6 years term. He may at any time resign his office by writing under his hand address to the President of India. He may be removed by impeachment, Article 148, 124(4). His salary shall be equal to that of Judge of Supreme Court, which is now at that time rupees 30,000 with effect from 1/1/1996. On retirement, he shall be eligible to the annual pension of rupees 15,000. In other matters, his account conditions of service shall be determined by the rules applicable to the member of the IS holding the rank of a secretary to the Government of India. He shall be disqualified for any further government office after retirement, so that he shall have no inducement to please the executive of the Union or any state. The salaries, etc., of the Comptroller and Auditor General and his staff and the administrative expenses of his office shall be charged upon the Consolidated Fund of India and shall thus be non-votable. Article 148. On the above points, thus the position of Comptroller and Auditor General shall be similar to that of Judge of the Supreme Court. The Comptroller and Auditor General shall perform such duties and exercise and such powers in relation to the accounts of the Union and of the states as may be prescribed by Parliament. In exercise of this power, Parliament has enacted the Comptroller and Auditor General's duties, powers and conditions of the Service Act 1971, which, as amended in 1976, relieves him of his pre-constitution duty to compile the accounts of the Union, and the states may enact similar legislation with the prior approval of the President to separate accounts from audit also at the state level, and to relieve the Comptroller and Auditor General of his responsibility in the matter of preparation of accounts, either of the state or of the Union. The material provision of this act relating to the duties of the Comptroller and Auditor General are to audit and report on all expenditure from the Consolidated Fund of India and of each state and each union territory having a legislative assembly as to whether such expenditure has been in accordance with the law. Similarly, to audit and report on all expenditure from the contingency funds and public accounts of the Union and of the states. To audit and report on all trading, manufacturing profits and loss accounts, etc., kept by the Department of the Union or the state. To audit the receipt of the expenditure of the Union and of each state to satisfy himself that the rules and procedures in that behalf are designed to secure an effective check on the assessment, collection, and proper allocation of the revenue. To audit and report on the receipts of the expenditure of all bodies and authorities substantially financed from the union or the state revenues, government companies, other corporations or bodies when so required by the laws relating to such corporations or bodies. As has been just stated, the duty of preparing the accounts was a relic of the Government of India Act 1935, which has no precedent in the British system, under which the accounts are prepared not by the Comptroller and Auditor General but by the respective departments. The legislation to separate the function of preparation of accounts from the Comptroller and Auditor General of India thus brings this office at par with that of his British counterpart in one respect. But there still remains another fundamental point of difference. Though the designation of his office indicates that he is to function both in Comptroller and Auditor, our Comptroller and Auditor General is so far exercising the functions only of an auditor. In exercise of his functions as Comptroller, the English Comptroller and Auditor General controls the receipt and usage of public money, and his duty is to see that the whole of the public revenue is lodged in the account of Exchequer at the Bank of the England, and that nothing is paid out of that account without legal authority. The Treasury cannot accordingly obtain any money from the public exchequer without the specific authority from the Comptroller, and this he issues on being satisfied that there is proper legal authority for the expenditure. This system of control over issues of the public money not only prevents withdrawal for an unauthorized purpose but also prevents expenditure in excess of the grants made by the Parliament. In India, the Comptroller and Auditor General has no such control over the issue of money from the consolidated fund, and many departments are authorized to draw money by issuing checks without specific authority from the Comptroller and Auditor General, who is concerned only at the audit stage when the expenditure has already taken place. This system is a relic of the past, for under the Government of India Act, even the designation Comptroller was not there, and the function of the Auditor General were ostensibly confined to audit. After the commencement of the Constitution, it was thought desirable that our Comptroller and Auditor General should also have the control over issues as in England, particularly for ensuring that the grants voted and appropriations made by Parliament are not exceeded. But no action has as yet been taken to introduce the system of exchequer control over issues, as it has been found that the entire system of accounts and financial control shall have to be overhauled before the control can be centralized at the hands of the Comptroller and Auditor General. The function of Comptroller and Auditor General have recently been the subject of controversy in regard to two questions. The first is whether in exercising his function of audit, the Comptroller and Auditor General has the jurisdiction to comment on extravagance and suggest economy. Apart from the legal authority for a particular expenditure, the orthodox view is that when a statute confers power or discretion upon an authority to sanction expenditure, the function of audit comprehends a scrutiny of the propriety of the exercise of such power in particular cases, having regard to the interests of the economy besides its legality. But the government departments resent on the ground that such interference is incompatible with their responsibility for the administration. In this view, the departments are supported by the academicians such as Appleby, according to whom to the question of economy is inseparably connected with the efficiency of the administration, and that having no responsibility for administration, the Comptroller and Auditor General of his staff has no competence on the question of economy. Audits do not know and cannot be expected to know very much about good administration. Their prestige is highest with others who do not know much about administration. Auditing is a necessary but highly pedestrian function with a narrow perspective and very limited usefulness. Another question is whether the audit of Comptroller and Auditor General should be extended to industrial and commercial undertakings carried on by the government under private limited companies who are governed by the articles of their association, or to statutory public corporations or undertakings which are governed by statute. It was highly contended by a former Comptroller and Auditor General that inasmuch as money is issued out of the Consolidated Fund of India to invest in these companies and corporations on behalf of the government, the audit of such companies must necessarily be right and responsibility of the Comptroller and Auditor General. While at present the Comptroller and Auditor General can have no such power unless the articles of association of such companies or the governing statutes provide for audit by the Comptroller and Auditor General, the result is that the report of the Comptroller and Auditor General does not include the result of the scrutiny of the accounts of these corporations, and Public Accounts Committee or Parliament have little material for controlling these important bodies spending public money on behalf of the government. However, this extension of the function of the Comptroller and Auditor General has been resisted on the ground that the Comptroller and Auditor General lacks the business or industrial experience which is essential for examining the accounts of these enterprises, and that the application of the conventional machinery of the Comptroller and Auditor General is likely to paralyze these enterprises which are indispensable for national development. As has just been stated, this defect has been partially remedied by the Act of 1971, which enjoins the Comptroller and Auditor General to audit and report on the receipts of the expenditure of government companies and other bodies which are substantially financed from the union or state revenues, irrespective of any specific legislation in this behalf. This is today's all about the part of the Union Executive. Thanks, regards.